Defensor Santiago be recognized.
The gentle lady from Iloilo.
Mr. President, yesterday you were struck by a thunderbolt. All of a sudden, the prosecution stood up and said, we have 8 articles of impeachment, but we are no longer presenting or withdrawing at least 5 of those articles, leaving us with only 3 articles of impeachment. In my entire career as an RTC judge of Quezon City, I have never seen a lawyer in a civil case, which is in this instance parallel to an impeachment trial, withdraw any cause of action that he told the court he would present evidence on. That has never been done. An impeachment trial is like a civil trial and like a criminal trial. An RTC judge's jurisdiction over all kinds of trials, civil, criminal, and special proceedings. I have never heard, apart from my own individual experience, I've never heard of a civil case where there are several causes of action, where the lawyer suddenly says to the judge, I'm sorry, Your Honor, I've made a mistake. I now want to withdraw or drop more than half of my causes of action. This is unprecedented. That is why I feel obliged as Senator Judge to enter into the record my very serious concern about this development. Number 1, Counsel, you please take a seat. Number 1, early in this trial, I asked both counsel, both panels, to please tell the court how many witnesses you will present and how many pieces of evidence you expect to authenticate by the testimony of your respective witnesses. Both panels submitted their so-called compliance. That is to say, when a judge issues an order and you comply with the order, you file a piece of paper called compliance, and then you attach whatever it is that the court wanted to see or hear or to read. There's a compliance dated 27 January 2012, filed by the House of Representatives, where the order of the court was, list down all your testimonial and documentary evidence on my instigation. And I have this copy of the compliance by the House of Representatives. Number 1, Article 1, partiality to Mrs. Arroyo in Supreme Court decisions. Testimonial evidence, 6 witnesses. Documentary evidence as appropriate. This is a long list of documents that this witness, 6 witnesses, were supposed to authenticate. Article 4, irregularities in the issuance of the status quo ante order on the impeachment proceedings of former Ombudsman Merceditas Gutierrez. Testimonial evidence, said the Prosecution Panel, 7 witnesses, plus the corresponding list of documentary evidence to be presented through those 7 witnesses. Article 5, gerrymandering in the creation of 16 new cities and the declaration of Dinagat Island as a province. Testimonial evidence, 3 witnesses. I'm quoting the Prosecution Panel. Documentary evidence, a list of cases. Article 6, allegedly improper investigation of Associate Justice Mariano del Castillo's plagiarism case. Testimonial evidence, 2 witnesses. Documentary evidence as listed. Article 8, failure and refusal to account for the Judiciary Development Fund and special allowance for the judiciary. Testimonial evidence, 7 witnesses. All these witnesses are listed here. What their names are, what their addresses are, and what is the purpose of their proposed testimony. Plus, of course, the documentary evidence to be authenticated by these witnesses. So, House of Representatives, January, tells us in the impeachment court, we will present these witnesses, we will also prove and authenticate, introduce into evidence and authenticate documentary evidence. Now, all of a sudden, it's only March, January, February, March, all of a sudden, there's a complete turnaround. Ni hi, ni ho, wala. Basta sabihin lang niya, ayaw na namin na presenta ng ebidensya. Ngayon, this is of very serious concern to me as a lawyer and as a former judge. Una, naglalaro ba, nagbibiro ba kayo? In writing ang inyong compliance nga. Sabi niyo, will present so many witnesses, so many documentary pieces of evidence. Pagkatapos ngayon, sabihin niyo, without explanation, our case is very strong, we no longer want to present evidence on these causes of action. You are prejudging the case. What are you conducting trial by? What are you doing conducting trial by publicity? Let me remind you, an impeachment trial is both quasi-judicial and quasi-political. But let me place this in context. In its quasi-political aspect, an impeachment trial is not to be decided by the reading public or the viewing public or by any of the publics that we are addressing. It is true that the Constitution provides sovereignty resides in the people and all government authority emanates from them. But Sovereignty resides in the people is a term of art in law, meaning to say it is a special code. It has a special meaning. It's not being used in its ordinary meaning. When the Constitution says sovereignty resides in the people, what people are we talking about? All 98 million Filipinos? Or all 65 million registered voters? A majority of registered voters? All survey firms? Or which survey firms are you referring to? Referenda? By certain NGOs? Referenda and surveys in certain campuses? No! This is not a direct democracy and we are not in Athens. The people are not going to decide this case. It is the Supreme Court and it is the High Court of Impeachment, this Senate, and the Senate alone that will decide this case. We are going to hold ourselves immaculate of all the propaganda that you're distributing abroad, meaning to say outside of this courtroom.